Welcome to Books of Our Time, produced by the Massachusetts School of Law and seen across the nation. Today we shall discuss a book called The Making of a Civil Rights Lawyer. Its author is Michael Meltzner, who was one of the major civil rights attorneys of the 1960s, working for the organization known as the Legal Defense Fund. Mr. Meltzner has also been a law professor at Columbia University, at Harvard, and the dean and a professor at the Northeastern University Law School. He is with me today to discuss his book, and I am Lawrence R. Velvel, the dean of the Massachusetts School of Law. Mike, thank you very much for being here. Mike, there are an awful lot of things of great fascination in your book. One doesn't have to be a lawyer or necessarily interested in history to think when one reads it that this is really an interesting book. And it starts out in major part with how you, the influences upon you that caused you to become a civil rights lawyer. And I don't know if foremost is the right word, but certainly eminent among them was your family history, what one would colloquially call as the genes or the background. I don't really mean the genes, or the background. I'd like to get into that, and why don't we start by having you tell the audience about the private file you found from your father.
Well, long after his death, I discovered in an old file in my own basement, something I had not examined before, a file documenting his search for employment during the 1930s, during the Depression. He was a New Yorker. He was interested in advertising. He ended up working in Dayton, Ohio, and Boston, and trying to get work around the country. And he encountered the first anti-Semitism that he had ever encountered, and it was pretty much documented in his file. To my amazement, in order to get work to support a new wife, a new baby, me, and his aged parents in a period long before Social Security really kicked in, he remade himself. And this second generation Jewish American became a Protestant, and his resume revealed
Not really,
that.
but that's the way he presented himself.
That's the way he presented himself.
Yeah. Oh, go ahead, I'm sorry.
Yeah, well, I think this explained a lot about my father. Perhaps it explained, in a way, his intense political liberalism. You've heard of red diaper babies. I think of myself as a sort of political liberal baby. My father was a man who followed politics avidly, who got involved himself peripherally at times, and who seemed to identify with the struggles of outsiders.
As I remember it, he actually hired African Americans for his company to work the Newark territory and work the, I think it was the Brooklyn territory, places where they would be dealing with African American customers. And even there, he had a struggle with his own company to some extent, didn't he?
Right. This was a national company that sold promotional materials, calendars, playing cards, business gifts. And this was the 1940s. And there were no Hispanics or African Americans working for this company. He was the first Jewish manager, actually. And I think, as I say in The Making of a Civil Rights Lawyer, it was very much of the time. You know, he spoke about this the way Branch Rickey talked about bringing Jackie Robinson into baseball. It was a kind of, I don't care what he is as long as he can hit or pitch, way of looking at it. But of course, it drew upon his social values. And he was extraordinarily pleased that these men were successful. Back in the home office, they didn't quite understand what he was doing.
Yeah. You know, one occasionally hears that about, I don't care as long as he can hit or pitch. I think one ought to remember that there were a lot of people who didn't care that Jackie Robinson can hit or pitch. And the Boston Red Sox, famously or infamously, could have had Willie Mays.
They could have had Jackie Robinson.
They could have had Jackie Robinson,
he got a
too.
tryout here.
Yes, that's right. And they could have had Mays as well. Well,
so we had to wait a good number of years.
Yeah, tough luck for the Boston Red Sox, and tough luck for the country in many respects.
I think they were the last team in baseball, weren't they?
They were. They had Pumpsy Green, I think,
right.
about 1959 or something like that. You say that most of the civil rights lawyers you knew had something of a similar tale?
Well, I think that they weren't all the same, but I think in many of them you found an injury, either through identification or directly. Whether they were Jewish or African American, they all had encountered in some fashion a sense of denigration, of dominance from maybe whites or a different social group, and there'd been a kind of ego injury, and I think that was the wound, and the bow was becoming an activist, becoming a lawyer. And I found that in many, many of my colleagues and many people who were active during the 60s and 70s. I want to make clear, though, they all didn't have the direct experience. I think many of them identified, and certainly World War II was something that led many Jews to feel they had to create a more humane society for their own protection, as well as for the protection of black Americans.
Yeah, yeah. It's completely beside the point, so I won't get into it, but one does hear today about the difference between Israelis and Americans who are Jewish as being a sense in Israel of they grew up being the top dog all the time, and it's a whole different psyche that one gets when one has been top dog, and one's people have been top dog. We had Louise Richardson on here, as I was telling you, in the last show I taped before this one, and she was talking about people who, through identification with others of the same religion, become, this is of course the extreme terrorists, even though they themselves have never suffered, as in England, say, or something like that. You talk a little bit, Mike, about the reverence for sacred texts as conceivably having had some impact on you. Can you explain that a little bit?
Well, I think, you know, there are different cultural adaptations, and I think Jews were people who were schooled in a way of thinking which was very much consistent with becoming lawyers. They were known as the people of the book. And so other groups of outsiders may have suffered the same injuries, Irish Americans, as you mentioned to me, but may have responded in a different way. I think it was very consistent for Jews to become constitutionalists. Yeah. It was metaphorically, at least, like the Bible.
Yeah, it's an interesting thing, Mike, because today our Asian immigrants and first generation, second generation Asian, the people from Vietnam and from Japan and from China and so forth, very committed to studying. And then with the Irish community, you had the savants is not exactly the right word. I forget, what is the word for people who have self-educated themselves so they know everything? And there was a lot of
autodidacts.
Autodidacts, thank you, yeah. I have the ideas and you've got the words, thank you. Autodidact. Irish are famous for working class autodidacts and so forth. Well, it's all kind of interesting. Joe McCarthy and Roy Cohn and Robert Welch, who was a Boston Brahmin, that all had an impact on you.
I think that, you know, it's hard to pick out one set of events, but I do think the McCarthy period was experienced by me and others like me as a direct threat. He was supposedly hunting for communists, but many of these communists were simply liberals. And it mobilized a resistance that was often a resistance in the hands of lawyers, civil liberties lawyers, civil rights lawyers. And I quote in the book, for example, Arthur Lyman, who was one of these New York super lawyers, who had the same experience I did. And he later became a person who accomplished a great deal in the public interest sphere, although he was the senior partner of a large law firm, but he always had a pro bono aspect to his work. And so I remember I went to Stuyvesant High School in New York City, and during the famous Army McCarthy hearings, I would get home because Stuyvesant had split sessions at 12:30, and I would sit for 2 or 3 hours and watch the hearings on an old black and white TV set, and it had an incredibly powerful impression on me. And of course, Joseph Welch was one of those advocates who was defending the little guy.
In fact, a very famous episode where he defended his junior colleague against it, and he said something like, "Senator, have you no decency at long last?" Very famous episode.
Right. His former colleague had had some connection with the National Lawyers Guild, which McCarthy was trying to make out as a communist front organization. And it had nothing to do with the purpose of the hearing.
And I think the National Lawyers Guild is still on the Attorney General's list of subversive organization. What a farce. What a farce. But there it is. There it is. Mike, you were exposed, and as I said said to you, to some extent I was too for a while in Chicago when I still went to high school in Chicago, to the idea that violence was all around you and you had to watch out for it at all times. What was the impact of this on you?
Well, when I lived in the middle of Manhattan growing up in junior high school and high school, it was the great gang period in New York City history. It was before heroin took the place of gang culture. And I think it confirmed perhaps a natural timidity or cowardice or self-protection, that one had to be very careful in dealing with violence, that not only in the obvious sense that you didn't want to become a victim, but that it could tear at the social fabric terribly, because the community in which I grew up in was torn apart by gang warfare. Young people were afraid to move freely in that
Did this have any impact on your turning to becoming a civil rights lawyer?
Well, I think just in the general sense of feeling comfortable with the issues of growing up in the middle of an integrated situation. You know, you basically were out to protect yourself in a chaotic social situation. Yeah. And it wasn't one group against another. It was much more complicated than that. Yeah. And I think that made me comfortable in an integrated setting. I think growing up in New York, more than the violence of it, was a key element that made me feel relatively comfortable going to work for a civil rights organization at a time when white people rarely did. I think today, I'm sure people look at it in a very different fashion, but I was only the second lawyer at the Legal Defense Fund who was white. The other was my soon-to-become boss, Jack Greenberg.
Right. Speaking of, or describing it as growing up in a chaotic situation, makes me think it was really good training for places like Albany, Birmingham, Oxford, Mississippi, Philadelphia, you know, and a scores of others you could name, because those were chaotic situations.
Yeah, I think there was an acceptance that if you grew up in New York City and somehow there could make it, you had to understand the contingency and uncertainty of modern life. Yeah, yeah. And certainly those movements, cities that you mentioned, were evolving. We didn't know what was going to happen.
Yeah, yeah. It's an exaggeration, but I did have a friend who turned out to be a nuclear physicist, and he was a very powerful guy and an athlete and whatever. And he once said to me a few years after we both graduated from college that if somebody could survive Chicago, they could survive anywhere. And you know, you could say the same about New York.
I think those are two tough towns.
Yeah, yeah, yeah.
And I'm sure your education in politics, just from watching what went on in Chicago, was extreme.
Well, the cops were the robbers. It was that simple. You don't talk much about the influence of Oberlin, where you went to college, even though it's historically one of the most liberal schools in the country and was a stop on the Underground Railroad. The only thing you mentioned about it was an awful passage from a leading, at the time, college history book by two of America's leading historians, Morrison and Commager. Why so little about Oberlin? Did it have no impact?
Well, I think it had enormous impact. I think I just probably took it for granted. There's so many stories, and I really wanted to focus on the impact of legal education. So I didn't go into Oberlin in great detail, but it was a very important place in my own development. It taught me to put my feelings in terms of ideas. And indeed, I had trouble in law school in the beginning because I found, as bright as my law teachers were, the way they looked at social problems through this narrow focus of the law seemed to me diminished compared to the way my Oberlin teachers looked at the same issues. So I'll have to write something to make it up to Oberlin because it was a great place and I had some wonderful teachers.
Well, I think you should write something not to make it up to Oberlin, but to let people know what it meant. Because I think those kinds of things are very important. I've written a little bit about that myself, but I doubt if mine was as influential or upon me or as colorful as I expect Oberlin was. Mike, tell us a little bit about what legal education was like at the Yale Law School when you went there from 1957 through 1960. It was the same as Michigan, I can tell you, and it was the same at Harvard. It's largely the same, I think, in many places today, though not as exclusively. And it did tend to, as you point out, it did tend to try to teach one to ignore one's own moral feelings. Why don't you discuss what it was like in those days?
Well, I think you're absolutely right that it was the same almost everywhere. I think the one thing about the Yale Law School that was different was that it had a strong public policy base, and it thought it was a very different environment for that reason. In other words, instead of thinking that it focused on litigation, it saw itself as a group of, as a scholarly community focusing on law and all those other disciplines, economics and international politics and sociology that related to it. This led to a variety of courses that were fascinating, but I always thought a little half-baked because they weren't, they didn't go into economics in that greater detail because they had to give you the legal side also. Like most law schools at the time and today, it was primarily a training ground for large firm practice, most Ivy League law schools at least then and now. And so ending up doing what I ended up doing was a little eccentric and odd, I think, to many of my classmates. Single practitioners and criminal defenders and civil rights lawyers did not generally emerge from a law school like Yale, although many public-spirited and influential lawyers did. But the standard way that they operated was to become powerful private practitioners and then devote part of their energies to public service. At the time I went to work for the Legal Defense Fund, I think I was one of the very few graduates of Yale who did that. There weren't that many jobs also. We now have
in the whole public interest
sphere.
Yeah,
we have today we have hundreds of jobs in the environmental field, disability field, immigration. Then the American Civil Liberties Union employed one lawyer. Right. When I joined Thurgood Marshall's staff at the Inc. Fund, or Legal Defense Fund as it's generally called, I think I was the 6th lawyer on the staff. Yeah. And so there's been a dramatic change in that respect, and the 1960s brought that about. One of the really interesting things to me was how 5 or 6 years after I started work, Law Review and Law Journal editors from around the country, from the most prestigious schools, all they wanted to do was to work for the Legal Defense Fund, at least in the summers. Whereas when I serendipitously and fortunately got this job, it was looked at as, well, he's a little peculiar anyway.
I take it, Mike, that you feel that to this day, law students experience a kind of malaise at most law schools because of the division between their moral side and what they are taught to do professionally, which is to ignore their moral side.
Yeah, I think that's one of the great burdens of practicing law, as you indicate. It's a very hard act to pull off. Yeah. Where you represent interests and clients vigorously, whose interests you don't in your other lives tremendously appreciate.
Yeah.
And I think it's probably necessary, but it's difficult.
Mike, how did you escape that? You talk about all the advice you got, sometimes from people who ultimately became quite famous, like Gerhard Gesell, not to do this, and that it was risky, and you should learn antitrust first, and et cetera, et cetera. How did you manage to escape all this good advice you were getting?
Well, I think we can talk about the social causes and explanations for why someone ends up doing the kind of work I did, but I think a piece of it is internal and familial, and I came out of my childhood with a certain kind of autonomy. Maybe it led me to grief in other situations, but here I knew what I wanted to do. I did not disdain corporate law. I simply thought I wouldn't enjoy it or be very good at it. I knew what I wanted to do, and for that reason I thought I could get away with it and do it. I went to speak. Gesell is different because he was one of the few interviews I had at the Yale Law School, and he didn't give me advice. He basically said, if you come to work for my big firm, he was not a judge yet, we won't let you represent poor people until you're an expert in securities law or real estate or something else. But when I arrived back in this country from a year off trying to be a freelancer and working for a newspaper in Europe and the Middle East, I came back ready to get married to a woman I'd met there, and her mother-in-law, or I mean my mother-in-law-to-be, insisted that I talk to these poobahs who were friends of hers.
Yeah.
And so she sent me to a federal judge and to a big-time law professor. And as I describe, I think they all identified with me in a certain respect. They thought that good works were fine, but that you had to have good suits, you had to have a summer house and private schools for your kids. And so they couldn't just say, go to work for one of these civil rights, civil liberties organizations. They thought that was valuable and high-minded, but the pay stunk. And so they couldn't tell me to do that. And I listened to them because I wanted to be I didn't want to have conflict with my mother-in-law, a formidable woman. But fortunately, my great constitutional law professor, Alex Bickel, said, Thurgood Marshall's job is the job for you. And I took it, and I really didn't stop for 10 years.
Yeah.
I was.
I got a big kick out of the fact that when Greenberg was interviewing you and he told you that the salary would be $6,000, you blurted out that you would take less if that were necessary. And $6,000 was comparable to what was being paid new people on Wall Street in those days.
It's right. The big shift took place a few years later.
Yeah.
And Greenberg said to me, I said this because my father had, I think, made $10,000 just a few years before his death, and I thought $6,000 was an enormous sum.
Yeah.
And I blurted this out, and he said to me, never take less money for doing good, and I was always very grateful to him.
Yeah.
And then I learned that Thurgood Marshall had hired him at a salary. The NAACP board had said, no, that's too much money, and Thurgood Marshall had to cut his salary. So he was coming from his own place of...
I once had an experience like that, Mike, where I told people what I wanted, and to my consternation, I could immediately see they would have paid me much more.
Well, that's the way it is in a negotiation. You walk out thinking, well, I really showed those people, and then you find out that they took you for a ride.
All right, we have to take a break. We will be back right after this break. We will be back with former Dean and Professor Michael Meltzner talking about his book, The Making of a Civil Rights Lawyer. Welcome back. So, Michael, you went to work for the Legal Defense Fund. Now, why don't you explain, first of all, what the Legal Defense Fund was and is, it still exists, and what its relationship was and became with the NAACP?
Well, this is a matter of enormous confusion, and the press still hasn't gotten it straight. Certainly the Legal Defense Fund still exists. It's still the most powerful legal civil rights organization in the country, and it still does wonderful work. But its origins were humble. It was just an office within the organization of the NAACP, which is a membership organization, and this was simply where their lawyers sat, basically, in the 1930s when a man named Charles Hamilton Houston, who had been the vice dean of Howard Law School and Thurgood Marshall's teacher, began to evolve the strategy that became Brown v. Board of Education.
Fundamentally, Houston, and maybe Margold, but Houston especially, is responsible for that strategy, isn't he?
I think so. Margold was someone who did a study about it and recommended a course of litigation. As many of your viewers may know, the NAACP beginning in the 1930s, set out to lay the legal foundation for Brown v. Board of Education by bringing suits demanding the integration of graduate schools in various states of the South. And ultimately won all those cases, and that led to a good legal argument that eventually the Supreme Court accepted in 1954. In any event, for many of the years leading to Brown, the Legal Defense Fund was just an entity within the NAACP. It had been set up in a way so that if you wrote a check as a contribution, you'd get a tax deduction, whereas if you were just a member of the NAACP, you wrote a check to the NAACP, that would be, in effect, contributing to a political organization. Well, in the 1950s...
You can't get a deduction for that. You can
right.
for contributing to a legal organization.
Right. In the 1950s, Southern segregationist senators, very powerful group in the U.S. Senate, complained regularly to the IRS.
People like James Eastland, I presume.
Pardon me?
People like James
Thurman and Eastland and
just
so forth.
awful people in history, but anyway.
They complained to the Internal Revenue Service that the NAACP, which was, after all, their boogeyman, their bête noire, to coin a phrase, was doing something unlawful by having this legal group within the association. So the IRS insisted that the NAACP and its legal arm, the Legal Defense Fund, split apart. And Thurgood Marshall basically took the legal group, made it a separate organization with a separate board, and soon it developed its own policy and procedures that were independent of the NAACP. The two organizations not only grew apart, but they ended up in conflict over certain things. And this was extraordinarily important for the civil rights movement because the Legal Defense Fund, which was an organization of lawyers with a board rather than members and a board, became the legal arm of the entire civil rights movement. Martin Luther King's lawyers were at the Legal Defense Fund. The Legal Defense Fund brought cases on behalf of all sorts of civil rights organizations, not just the NAACP. And in fact, there was always an underlying connection between the two, because many of the lawyers in the South who had steered the clients to the Legal Defense Fund, who were the local counsel in many famous civil rights cases, were also NAACP members. They were called cooperating attorneys. So these people could be NAACP members, they could be cooperating lawyers for the Legal Defense Fund, and there was a confusion built into their relationship, which lasts to this day, although in the 1980s there was an ugly lawsuit brought by the NAACP, which has always needed money, against the Legal Defense Fund, saying, "You're trading on our name." And the defending civil rights demonstrators in poverty cases, in affirmative action cases, in the maldistricting cases, in the Muhammad Ali case. I mean, you name it, the Legal Defense Fund was there. Well, I think, you know, what it did was it freed the organization from the weight of this membership body and its board that was responsive to a different constituency. The Legal Defense Fund is basically responsible to itself and its board, which was largely dominated by lawyers. And so it immediately could see itself as taking such lawsuits on that would advance the cause of human rights. It didn't have to deal with the politics of a larger membership organization. So it's very important in that respect.
Anytime you can avoid the politics of anything, you're well off. That's just
well,
a rule of life.
The NAACP has been plagued to this day with these issues, and the Legal Defense Fund has been free of them.
And I must say, especially in the last 10 years has the NAACP been, or maybe the last 15 years has it been plagued with these kinds of issues. Talk a little bit, this might sound unusual to people, talk a little bit about the secretaries at the Legal Defense Fund and the contribution they made and the importance of knowing them.
Well, I think they were among my greatest teachers. These were women who were full of life and energy. How they managed to work as long as they did into the night to produce these civil rights briefs. This is long before we had computers. Xeroxing then, or photocopying then, was an agonizingly slow process, page by page. These
still used whiteout in those days.
Yes, and all these women had been at the Legal Defense Fund for many years. They were fully aware of the behavior of civil rights lawyers, of who to trust, of what conditions were like around the country, and to come into the culture of this organization for someone like me. And I think the same was true for many young black lawyers. These were the people who told us, you know, how to do what you had to do in the proper way. They had a great sense of history of the organization. They understood the male animal, and there were certainly some interesting people who passed through our office. Almost every major black figure did it one way or another. And of course, Thurgood Marshall was a charismatic and complicated human being. He was he led through indirection, through anecdote, through story, through joke, and you often needed translation to make sure that what you understood him to have said or conveyed was correct.
Why do you think he adopted this kind of a persona? Well, I mean, maybe he didn't adopt it. Perhaps it was natural to him. But is it possible that it was adopted, and if so, why?
Well, I think it was part of the outsider experience, which you pointed out to me in an email. It probably began in Baltimore when he was an obstreperous young kid on the go, and he needed to learn a variety of urban strategies to protect himself. I think one thing he needed to do was to not be fully accountable to hostile people. And so he could not always be pinned down. I have a strong sense that this is where it came from. And you know, when you were on the left in those days, especially if you were fighting for equality, you would be tarred with the communist brush, even before McCarthy. And civil rights lawyers of Marshall's time had to be very careful what they said, because the segregationists and their allies would claim that they were just agents of the Kremlin. And so I think all this contributed to Marshall being someone who was very careful and cunning about what he said and how he said it.
You know, Baltimore in those days, when he was growing up in the 30s and 20s, was a very southern city. And there's no doubt that the lives of civil rights lawyers were in danger in the South. So you did have to be extremely careful. I've been reading about that in another book. You had to be very, very careful.
Oh yeah, there are stories that he would tell, or Jack Greenberg would tell, of of him basically being told, get out of town by nightfall.
Yeah, yeah,
And
yeah.
he was not, in those days, when he was learning his trade, he was not protected by the Department of Justice. There were no FBI agents even around just to watch him be beat up if he was going to be beat up.
Yeah.
There was no one to protect you.
Yeah.
And so you had to be very careful what you said and how you said it. And he also was appearing in court in these towns.
You know, people really don't like to hear it, but I think it was Howard K. Smith who had covered Germany at the time of the Brown Shirts and Hitler, who said during the civil rights movement in places like Birmingham and Mississippi, he had not seen anything like this since he had left Germany in the 30s.
Well, you know, that reminds me of something. You know, I think one of the reasons why I could translate Thurgood Marshall's locutions without a great deal of fuss, just a little help from the secretaries, was that I had experienced something similar in watching the way Central European Jews dealt with Gentiles, not directly, of course, but by kind of picking it up culturally. I think they were in the same relationship to a dominant group that Negroes were in the South in the 30s and 40s and 50s, which is when Marshall acquired the fullness of his style. He even, you know, when he was on the Supreme Court, maybe we'll get to this later, but he would often ask questions of advocates before the Supreme Court, and in a way that the advocates thought was indirect and somewhat cryptic. But by that time, I think I'd learned what his approach was.
Yeah, it's a problem for all people who are on the outside, who are despised. You know, speaking of being despised, watch and see in the next 10 years, more and more is going to come out about the contributions, I use the word advisedly, the contributions made by the Communist Party to making this a better country in the 20s and 30s, when only the communists, God help us, only the communists were as an organization fighting on behalf of African American rights, fighting on behalf of control of the police. The communists did a lot of things in this country that are going to be coming out because the Communist Party, you may have read about this, the Communist Party's files only now are being opened.
I have noticed that.
Only now are they being opened. And there's bad coming out too, that they were indeed the agents of Stalin. But there will be good coming out as well as the bad further coming out. Mike, you talk about the fact that I think this is really wonderful because I'm so bugs about the idea that working at the Legal Defense Fund required super competent work. You couldn't do a half-baked job. It had to be the very best. Can you elaborate that, why and so forth?
Well, I think when I started on some level, I expected that because I was representing the good, the true, and the beautiful, that all one had to do was to present the facts to the judges, and we'd win these cases. I mean, how could one oppose what we were arguing for? But in fact, these were lawsuits like any other, and to my amazement, I fast had to become as knowledgeable about procedure and property law and tort law and other aspects of legal work as much as civil rights statutes. So,
because all those things are involved in the cases.
Because, first of all, there was an enormous resistance to what we were saying. Secondly, there were a host of technical defenses raised. After Brown and the cases following Brown, the defendants, the segregators, the people who were opposing equality, didn't have very good arguments left for the ultimate issues. So what they did is what lawyers always do. They try to proceduralize everything. And suddenly they would raise defenses about how the case was brought and whether the steps had been, whether administrative remedies had been exhausted, and all sorts of things that lawyers know delay final decisions. So civil rights lawyers were not really just people talking about ultimate values and goodness and justice, we had to deal with as many technical concerns as any lawyer would in major lawsuits. And I suppose another aspect is that these cases became front page events. And if not always on the front page of the Washington Post or the New York Times, although often, they were certainly front page events in the states in which they were taking place. And so given that fishbowl atmosphere, one had to be a very careful lawyer.
Yeah. You describe your initial trips to the South as being something like this proverbial stranger in a strange land, and that changed. Explain why that changed as you got to know the people and the lawyers and so forth.
Well, it was, I'd been south before, but as a kid with my parents, and I had no real sense of the differences in culture. And suddenly I was thrown into these contested situations, and I was a white person living by and large in the black community. In the first years, public facilities were still segregated. And even after they were integrated, I spent most of my time with my local contacts, and this was a great education. I lived in places and with people who did things that were totally different than my own experience. And then to go back from when a trial or a hearing was over and to suddenly be living on the west side of Manhattan, where I'd grown up, overlooking the Hudson River, it was schizophrenic making, schizoid.
Yeah, right. Okay, we have to take another break. We'll be back again with the third segment of our program with Professor, former Dean Michael Meltzner on his book, The Making of a Civil Rights Lawyer. Stay with us. Welcome back. You mentioned that sometimes what the lawyers wanted in a case was not necessarily, particularly as the case is dragged on due to the other side's machinations, what the clients ended up wanting. Why don't you discuss that a little bit, and what the Supreme Court, at least some justices of the court, seem to think about that?
Well, let me take the second piece first. I think because the Legal Defense Fund had been the moving force behind virtually every major civil rights decision for decades. And
what a fact that is, Mike.
The sit-in cases, the freedom ride cases, the cases leading to integration of transportation and hospitals, Brown v. Board of Education. And because of the larger-than-life stature of Thurgood Marshall when he was the director counsel, and I must say the high quality of legal work that the Legal Defense Fund did. It, after all, had more cases before the Supreme Court than any law office in the country except the Department of Justice. The justices over time began to think that the Legal Defense Fund had managed cases so that they came to the Supreme Court in a certain order, in a certain way. And often the justices feared or anxious that they maybe were being led down a path where they didn't want to go. In other words, if they decided a certain case your way, although they were perfectly able to say no, as they did in certain cases, that they'd be in a place where the court was exposed to criticism, that its credibility was affected, or they'd have precedent that they didn't really want to follow. And they attributed this to the Legal Defense Fund. Now, I think at times this became critical with the particular justice's vote to hear a case or not. I think in the capital punishment area, where the Legal Defense Fund became the primary resource for many years, they were particularly on guard against this phenomenon. Which is funny. From the Legal Defense Fund side, well, yes, we try to plan and orchestrate our cases, but the life of the law is so complicated. Cases would be won at a lower court. Litigants would drop out. Issues would change. You could stand there like a general and say, this is my military campaign, but if the cases were like soldiers, they were marching off in many different directions. It was not nearly so organized as all that. Now, there were some instances, especially in the education area, where the cases went on and on and on, and the views of the community changed. It was understandable and occasionally happened that the majority of black parents in a particular school district would basically say, we're sick and tired of waiting for full integration. Just get us better schools. And of course, the National Office of the Legal Defense Fund had come to its own powers around the notion of integration, not separate but equal. So this led to a variety of conflicts in particular school districts. The point, however, is that in most places, integration was the fastest way to get equal educational opportunity. It may not have been the only way, but it was certainly the fastest way. And so the Legal Defense Fund pursued this first and foremost because it believed in it and because it was trying to demolish a segregated society, but also because it was a way of ensuring more educational inputs for the black community.
Now, that relates to something, a position that has long been taken by a former office mate of yours named Derek Bell, who became both a very famous professor, a very famous dean, as I understand it, as I remember, a law professor to this day. And Derek Bell's position was, shades of separate but equal, that integrated education is a bit of a farce, and that what the African American community needs is not integrated education, but good education. What was the LDF's reaction, if I stated it, Bell's point rightly, what was the LDF's reaction to that?
Well, I think the major reaction was, well, that's all very fine, but how do you get it? And there the two parted. Derek is a very charismatic, a powerful intellect, perhaps the most influential African-American law professor of his time. He was the first tenured, he was for a long time the only tenured law professor at the Harvard Law School. Probably not the first, but he was maybe the second. And he was a dean of a law school, and he wrote prolifically and still does to this day. And Derek's view was very skeptical of integration, and he basically wanted to turn schools over to the black community because integration had failed. And if you look at the statistics and the resegregation of American schools and the chronic problems we have in assuring a quality education and in narrowing the gap between majority and minority performance, there's a lot to be said for his point of view. The problem, the difference, I think, is largely tactical. In other words, how does one change the situation? And by just abandoning integration and saying, well, let's have better schools, does not get us there. In many, many places, integration was the only way. After all, the Constitution says something about integration. It doesn't say anything about education. And as integrating the schools was part of dismantling the entire apparatus of white supremacy, you can see how we got there. The difficulty we continue to face is that our educational system just isn't producing the results we want.
You know, there was once a case that involved this, and I would say the minority community lost, Texas versus Rodriguez or something like that.
San Antonio School District.
Okay,
versus
thank you.
fair.
And when you get to that kind of thing, and you point out poverty law and various other kinds of economically based rights, that's much harder to win, you say, than simply a case involving de jure segregation. And what are some of the reasons why, in your opinion, these cases are harder to win?
Well, I think first of all, the espoused values of our country, quite aside from performance historically, but the espoused values for some years have been that equality when it comes to race is the way to go. It's the preferred value system. We're much more ambivalent and uncertain about that when it comes to wealth. Secondly, the decisions themselves are not nearly so amenable to judicial action.
Why is that, Mike?
Well, I think they're distributive decisions. They're decisions about who gets, who wins, and how much. And those are decisions which we have consistently left to legislatures, to the political process, as opposed to saying, no, you cannot discriminate on the basis of race. To say, no, you can't discriminate on the basis of wealth, ask us, well, how do we do something about that? That's a political set of political decisions, and people in political situations vote their self-interest. Principles have less to do with it, and that means in a plural society that many voices are going to be heard. Many people think they have a right to certain resources. I mean, today we see how anti-terrorist funds are disputed in the legislature, and various parts of the country say, no, we're entitled to our share. Well, that is writ large when it comes to eliminating distinctions and disparities of wealth. And the courts have never felt comfortable doing that for a variety of reasons. And they shied away in the 1970s from carrying the racial precedents into that area.
Mike, because in your opinion, which seems to me well-grounded, we must depend upon legislatures when it comes to disparities arising from the rather remarkable disparities in wealth in the United States. We have come to rely on what is called democracy. You think that we have a democracy in this country?
Well, we have many democratic institutions and we have many lapses. Many ways in which if democracy means the majority rules and there's a certain respect for minority rights, but in distributive issues, majority concerns will rule. We have a legislative process that is highly impacted by political contributions, by gerrymandering, and by structures that put power in very few hands.
Within the legislature.
Within the legislature.
Yeah.
So it's hardly when Nevada has the same number of senators as California, as historically understandable as that is, it's hard to talk about a pure democracy. I suppose if we look around the globe, we're doing pretty well, but by our own standards, I think we're falling short.
Could the courts not say, if they were so disposed, Mike, which I realize they're not, but if they were so disposed, could they not say to the legislature, look, we've got a problem here, whether it's inequality of schools, inequality of hospitals, inequality of income, call it whatever it may happen to be. The courts are not perhaps properly equipped to deal with it, but we're telling you that what you're doing is wrong, and you better get on the stick, because we don't want to find ourselves 10 years from now in a position where we're going to have to say, okay, guys, you didn't do it, now we're going to have to act. You'd better act. Some courts have done something like that in some areas. Why couldn't more courts do that?
Well, we don't teach law students, by and large, that when they become lawyers and judges, they can do that. It's been very rare, and I think historically in this country, that that's been the understanding of the courts of their function. They do that sometimes, usually when there's a crisis or something is extreme. You know, my great teacher wrote a book called The Least Dangerous Branch. Well, the least dangerous branch, the judiciary, is also a branch which depends on a kind of moral and ethical support. One has to believe in the rule of law. And I think the courts are always fearful, even those judges and justices who would go in the direction you're talking about, they're fearful that they'll be told no. And that once they're told no, they'll be told no again. And finally, they won't have a very important role. So in that way, we talked about earlier about indirection in Thurgood Marshall. You know, the judiciary, when it's doing good, often behaves in the same way. Nudging, pushing, suggesting, encouraging. And I think that's the modest role that even judges who are progressive in their view believe is the proper way for courts to act.
Yeah. We have about 30, 40 seconds left, Mike. There are people who say, you discussed this rather extensively, that Brown versus the board really did not have an effect. What's your judgment on that?
Well, I've never quite understood. I think there are two kinds of people who say that. One are the disappointed. They thought Brown was going to solve all our problems, and it plainly hasn't, and so they've kind of turned against it. Secondly, there are people who for a variety of reasons, feel that the judiciary can't be the place where significant social change emanates from. And as Brown is held up as the great exemplar of how, when courts do things, social change follows, these folks have taken a very critical stance towards Brown. Of course, Brown, we think of as, we're talking about Brown as if it's the decision that said no more separate but equal. But there was a second Brown case which said integrate those schools, desegregate those schools, whatever, by all deliberate speed, which basically said, well, do it when you get around to it.
Big mistake.
Yeah.
And ultimately, I suppose it's true that Brown by itself couldn't do, and this might be true of courts generally, it requires the media, it requires action by the executive, action by the legislature. It sets in motion a process, and God knows Brown did that. In fact, I have just recently read that a lot of the young people who were leaders of the civil rights movement in the South in the mid-'60s and late '60s were people who had been in, say, the 5th or 6th grade when Brown came down, and were very disappointed that more hadn't changed to their benefit over time.
I think you've got it, you've nailed it. All the courts do, even in a major decision like Brown, is to start something and to keep it going. But for anything we would call success, requires the rest of government.
Yeah, we have to break. We're done. We have no more time.
It's been a great pleasure.
Thank you, Mike. It's been mine. To the audience, be with us again next time for the next installment of Books of Our Time.